Insular Life Employees Company versus Insular Life Association. Facts of the case: the Insular Life Assurance Company Limited Employees Association, FGU Insurance Group Workers and Employees Association, and Insular Life Building Employees Association, while still members of the Federation of Free Workers, entered into a separate collective bargaining agreement with the Insular Life Assurance Company and the FGU Insurance Group. Enaje and Garcia of the union tries to dissuade members of the unions from disaffiliating with Free Workers Federation and joining National Association of Trade Unions, to no avail. The said two lawyers then left Free Workers Federation, and both secured employment with the Anti-Dummy Board of the Department of Justice. Thereafter, Enaje and Garcia were both hired by the companies in 1956 and 1957 respectively. The unions submitted proposals to the companies for a modified renewal of their respective collective bargaining contracts, which were due to expire by September 30, 1957. The parties mutually agreed to extend the existing contract until November 16, 1957, and make benefits agreed upon effective retroactively as of October 1, 1957. Negotiations were made but were snagged by a deadlock on the issue of union shop. Unions filed notice of strike because of this. After several requests, the companies did not make any counter proposals and insisted that the unions drop their demand, and they were promised money benefits when it is done. Insular Life Assurance Company Employees Association dropped the demand, but the respondents still refused to make any counter proposals. Negotiations were made, but there were no final counter proposals on their demand for salary increases. Instead of giving counter proposals, companies requested the unions to submit their own proposals considering the financial position. Meanwhile, 87 unionists were reclassified as supervisors without salary and responsibility increase, who then resigned from the union. Unions went on strike and picketed the offices of the respondent. While this is so, companies sent individual letters to strikers. Some were convinced to desist. A fight ensued between unionists, and those who desisted both suffered injuries. Eventually, striking employees went back to work. However, they were required to secure clearances from the City Fiscal's Office of Manila to be screened by the management committee, among the members of which were Enaje and Garcia. The said committee rejected 67 strikers with pending criminal charges, while the non-strikers with pending criminal charges were readmitted without the need for clearance. Prosecutor filed a complaint for unfair labor practice, but this was dismissed due to lack of merit, to which the petitioner filed a motion for reconsideration, which was also denied. The issue here is whether or not the presiding judge, Arsenio Martinez of the Court of Industrial Relations, and the counsels of the private respondent should be cited for contempt on account of what the former wrote in the decision subject. The ruling of the court is yes. Presiding Judge Arsenio Martinez and others should be cited for contempt. The respondent judge wrote in his decision, subject and quotes the same on the respondent's brief. It is plain to the naked eye that the 60 ununderscored words of the paragraph quoted by the respondent judge do not appear in the pertinent paragraph of the court's decision. Moreover, the first underscored sentence in the quoted paragraph starts with "for it is settled," whereas it reads "for it must be remembered" in this court's decision. Finally, the second and last underlined sentence in the quoted paragraph of the respondent judge's decision appears not in the same paragraph of this court's decision where the other sentence is, but in the immediately succeeding paragraph. Happily for the respondent judge and the respondent's counsel, there was no substantial change in the thrust of this court's particular ruling which they cited. It is our view nonetheless that for their mistake they should be, as they are hereby, admonished to be more careful when citing jurisprudence in the future.